Hey, good afternoon, everybody. This is John. Normally, I like to get these videos posted a little bit earlier, and so I apologize for that. And I promise you that I do have an office where I go and work. I'm home again today, and I know what I was last week due to the snowstorm, and this week I actually had jury duty this morning, so I got to witness. Um, I was in there for about 4 hours. I didn't get called, but I was. Got to witness what real lawyers do for a living. So it was quite an interesting experience. But fortunately, I didn't get picked. It was sort of a 2 day criminal trial, and that would have really thrown a wrench into my schedule. So hopefully, or I'm grateful that I wasn't picked. So, anyways, I like I said last time, I like to post these videos each week. This week, I want to talk a little bit about the legal system, just sort of the whole regulatory environment, the regulatory space related to healthcare, and and go from there. So, before I do that, I just want to quickly talk about the discussion questions. So, the initial posts have been great so far. I think I've graded about half of them. Um, with respect to the responses, we've had really good engagement. On the responses, um, what I really look for is a way for you to develop the initial response to which you're responding. So that can be done in a variety of ways. But what you're doing is you're building, you're adding, you're developing, and I think that's a great way to add value to those discussion boards. Um, as opposed to just responding. So I view responding a little bit differently than developing, which is which I think is what provides the most value. And you can develop those initial posts through your response posts in a variety of ways, including your own personal experiences, which is great, and we've seen a lot of that so far in class, which has been really awesome. I think actually that's a really great way because it sort of synthesizes the material and the concepts that we're discussing in class with your own experiences, and I think that's a great way to sort of really gain understanding of the concepts we're discussing. But it doesn't have to be personal experiences. You can do personal experiences, just concepts, material from the text, your own secondary research, some article that you saw. There could be a bunch of ways. So I really think that's the way to get the most value out of those discussion boards and through your engagement throughout the week. I apologize for my voice. I've been doing everything I can to fight off head cold, and I think I've been mostly successful, um, but the voice is kind of wavering. So anyways, that's it on the responses. So if if you have any questions on that, let me know. Of course, if you have any questions on my grading, please feel free to reach out. I will not be offended at all. Like I'll say several times throughout the next 7 weeks that I'm a human with grading, and I follow the rubric and do the best I can. So I think you're all doing a great job so far. I want to talk a little bit about the legal system a little bit. Like I said today, I got to witness at a jury selection. I got to witness a couple of lawyers actually doing lawyer work. I don't really go to court very much. I've been to state court a few times. I do some litigation, but it's all really administrative. So I do a lot of administrative litigation with CMS. If you're not familiar with CMS, it's the Centers for Medicare and Medicaid Services. A lot of state Medicaid litigation, facility licensure. I've represented some physicians in disciplinary cases in the past, but very rarely does that make it to an actual state court, state district court. Sometimes it does, but not very often. And on those issues, you go through this administrative process, appeal process. Well, let's say, for example, with reimbursement, there's an audit, you dispute it. There's an appeal process, and you've you've appealed as much as you can with CMS, for example, and then at that point you can take it to a either state or federal court, depending on if it's Medicare or Medicaid. But there are government licensing issues, a variety of things, even physician or practitioner disciplinary matters. Once you've exhausted all your administrative remedies, you can ask a state district court to review. It's called judicial review, to review the decision of the administrative agency to make their determination on that. So I've done that a few times. But I want to call out your attention. I think a lot of the litigation we're talking about, of course, we're talking about the Itraldi case, is in the medical malpractice sphere, and I did a little bit of that when I first became a lawyer, mostly doing the writing part, not really going to court. But medical malpractice, I think I said this last week, or professional liability, they're really negligence cases. And the key is liability does not automatically attach if something goes wrong. And there's a question on page 158 of your text, I think it's in chapter 6, that asks whether you could be sued for negligence if a patient is injured through no fault of your own. Well, the answer is yes. You can be sued for anything. You could be sued. I could be sued for. You could sue me for posting an incredibly boring video on YouTube. You might actually win that one, but you could really be sued for anything. If something goes wrong, someone is emotional about it, and their life is impaired by whatever went wrong. That certainly increases the risk of an actual lawsuit. Now, whether you can be successful with that lawsuit is totally different. That's where the elements of a negligence or medical malpractice case comes into play. Again, I'm going to emphasize this every week because it's so important. When we talk about legal components, especially when we're talking about the Itraldi case and your analysis of the legal side of things, we're talking about breaking it down into those 4 elements. What is a negligence case? Well, there's a definition of negligence, but in order to show a case of negligence, you've got to break it down to its 4 elements. Okay, so the first one is duty. Is there a duty by the physician? Dr. Ricketson, for example, does he have a duty towards the patient? Well, you can't answer yes or no unless you know what the rule is. And so once you understand what the rule is, then you can start to apply facts and analyze that. Well, what is the rule? Well, the rule for duty is whenever that physician-patient relationship is established. And, so what facts demonstrate that relationship has been established? And then, so what's your conclusion? So that's element 1. Then move on to element 2, which is a breach of that duty, right? So to establish a breach, you have to establish a standard of care. And the standard of care can vary. I'm just talking generally. Generally speaking, it can vary. It can be, is the standard of care the same in a urban sort of hospital in New York City where they have access to all kinds of specialists and equipment? Is it the same there as it is maybe in rural western Kansas, for example? So is that the same standard of care? Well, if the negligence, the so-called negligence, occurred in Western Kansas, some rural medical facility, the plaintiff would say, "Oh, it's absolutely the same standard of care. We have the internet. Everyone, even Western Kansas, has access to the internet, and you have access to all the current medical publications, and you should know X, Y, and Z. You have no less information than a doctor in urban New York City or some other big city, LA or wherever." And the defendant is going to say, no, it's a lesser standard of care because we are a small rural facility out in the middle of nowhere. We don't have the same equipment. We only have specialists that come out twice a week. And so, anyways, it's a constant battle that takes place in these sort of malpractice cases. So that's it's kind of this local standard of care versus a national standard of care. So the third element is injury, right? Or no, I'm sorry, causation. Uh, did the negligent, the so-called negligent act, or the act that's in at issue, did that actually cause the injury? And then there's a whole analysis and litigation that occurs there, and so, with respect to, did the patient have prior history of whatever ailments the patient has, or is there, would the injury have happened regardless of whether or not the act occurred? I mean, was it caused by some prior history of heart disease, or whatever it is? And so the question is, because if there's no causation, there's no negligence. It didn't cause anything. And the fourth is damages. So was there injury? And if so, what were they? And was the patient young or old, healthy, not healthy? What's the level of impairment? All those things are litigated and argued between the parties. So when we talk about the legal components, it's really important, and you're going to be doing this analysis in your projects. When we were talking about legal components, you got to break it down into those four elements. And if you have any questions, please let me know. But it's duty. I think your text calls it the 4Ds, but it's duty, breach of that duty, or dereliction of duty, which is what I think your text calls it, causation, and damages. So that's, and you're going to go through that IRAC issue, rule, application, conclusion. You're going to go through that method of legal analysis for each one of those elements and come up with your conclusion. So that's really important. With respect to the legal environment and healthcare, I wrote down some notes on, just off the top of my head, some of the laws and regulations that we deal with in healthcare, and you're all pretty much in the healthcare space. I think all of you are. So you're very familiar with most, if not all, of these things, like HIPAA. We're going to be talking about HIPAA, Stark Law. I'll talk about that another week. Anti-kickback statute, Medicare conditions for coverage or conditions of participation, False Claims Act, beneficiary inducement, civil monetary penalty law, Medicaid rules and regulations, state fraud and abuse laws, insurance regulations, privacy rules, patient abandonment, state licensure rules, accreditation rules, informed consent laws, Good Samaritan laws, living wills, DNRs, etc., end-of-life laws, antitrust laws, and then there are facility-specific laws, like for academic medical centers, ambulatory surgery centers, SNFs, critical access hospitals, rural health clinics, FQHCs, etc., etc. And then FDA laws and regulations, which we're going to talk about, I think, maybe week 5 or 6. But we're going to talk about clinical research, drugs and medical devices, so many more laws and regulations that govern clinical research that we'll get into a little bit. Scope of practice, medical records, which HIPAA is not the end-all be-all in terms of medical records. Medical records are actually largely governed by state law, and we'll talk a little bit about that. So anyways, great job, everybody. Again, if you have any questions, please let me know, and we're off to a great start, so let's keep it going. Thanks. Bye.